Good morning, good evening, good afternoon, depending on where you are joining us. On behalf of the Constitutional Studies Center of the Supreme Court of Justice of Mexico and the Law School of Leiden University, we welcome you and thank you for your attendance to this second session of the cycle of conferences on access to justice for boys, girls, and adolescents in the framework of the optional protocol number 3 to the Convention on the Rights of the Child. Today's session will be specifically about matters related to the admissibility of the complaints formulated using Protocol 3, some lessons and criticisms that can be observed in the framework of the jurisprudence that we know so far from the Committee on the Rights of Children. And we have two excellent professors and professionals, human rights activists and friends that will be with us this afternoon. I'm going to give the floor to Professor Ton Liefaar, Director of the UNICEF course and the Program on the Rights of Children of the Leiden University, to greet you. And Ton will introduce our first speaker. Thank you very much.
Thank you so much, Nicolás. Good day to you all. Good morning, good afternoon, good evening. We feel very privileged to offer to you the second webinar of this series focused on access to justice for children in the particular context of the optional protocol under this Convention on the Rights of the Child on a communications procedure. Greetings from Leiden University. It is a true pleasure to offer you this webinar series together with the Center for Constitutional Studies of the Supreme Court of Mexico. And we are very grateful for the opportunity also to join forces with this established center and to work together with esteemed colleagues from across the globe. But of course, a good webinar series cannot do without interested participants who are really eager to learn and to engage with us, together with us on these important matters. So it is a true privilege to join you today again. We have two esteemed scholars with us today, as Nicolás already pointed out, and it is my pleasure to introduce to you our first speaker. And this first speaker is Professor Dr. Ursula Kilkelly from University College Cork in Ireland. She's a widely known and very experienced international scholar on children's rights, and she has published and researched children's rights for over 20 years. And she has published many different publications, articles, as well as books on children's rights implementation from various perspectives. The most recent edited volume concerns a very important and rather innovative analysis of children's rights implementation, more specifically the measures, an analysis of the measures being adopted to incorporate the Convention on the Rights of the Child and its optional protocols into national law. And this book is published by Intesentia Publishing. But she has done much more than that, and she is not only concerned with research and teaching in this very important field, but she is also involved and connected to strategic litigation, more specifically strategic impact litigation, revolving around the use of the law to advance children's rights at the national level. So Professor Kilkelly, dear Ursula, it's a wonderful privilege to welcome you here and a great opportunity again to work with you in this webinar series. The floor is entirely yours.
Thank you, Ton, and afternoon, good morning, everybody. It's a great pleasure to be with you this afternoon. I love these international conferences where you can be moving quickly from one country to the next in the flick of a switch or the click of a button. So as I said this morning, going to Mexico this afternoon, I wish. So great pleasure though to be here, and thank you to Nico and yourself for the invitation. This is a really important subject. both from a theoretical point of view, but also from a practical point of view. And as you yourself have commented, Ton, in your own work, you know, we have not interrogated sufficiently what access to justice means for children. We have done a lot of work to adapt justice processes, and the work on child-friendly justice in particular is really important to ensuring there is a sensitivity and an awareness to the particular circumstances of children and the challenges they face in accessing justice. But the concept of access to justice, the use of the law in all its forms by children, is really not very well developed. And the only other opening remark I would make is that that is really evident when you look at the third optional protocol, and to be honest, also the rules of procedure, and to some extent the decisions now coming from the committee. There really is a need to engage in a much more considered and detailed manner with children's experiences of justice, children's experiences of processes and mechanisms that are ostensibly there to provide them with a remedy, yet ultimately fail even to appreciate what that experience might be like from a child's perspective. So I think that's you know, the obvious open sort of critical remark to make, that until we understand what children need from systems of justice and are prepared to hear about those experiences, we really will struggle to adapt what are very formalistic and sometimes bureaucratic and sometimes are often inflexible systems to children's very particular circumstances and needs. So that's the opening remark I'd make, and it's interesting, having just written a piece for an edited collection on children's access to justice at an international level, how striking it is that we have, I suppose, failed so far to really create a system that provides children with access to justice at an international level. The other point I would make, again by way of preface, I suppose, is that the international instruments, particularly the Convention and General Comments, talk a lot about children's access to remedies, talk a lot about the expectations on the national authorities of adapting their systems. Yet we still, I think it's fair to say, have a system at an international level, imperfect and all as it was in terms of its adoption, that is still fairly unadapted, or it has not yet been sufficiently adapted to be available and accessible to children. The result is that we are dependent, children are dependent almost exclusively on adults to access justice. And so what we'll see in the discussion, I think this afternoon, this morning, is what happens when that is the approach that's in place. So I suppose that's my starting point, and I'll come back to those issues as we go through. I want to just share my screen. Just 1 second now. Apologies. No matter how many times you practice this, when you go to do it, it seems to not want to behave. Now, you should be able to see that presentation. I should say welcome to University College Cork, by the way. This wonderful building is what I see from my window when I'm in my office. And it's a wonderful place to work and to study and learn. So sometime, someday, hopefully, we'll be able to invite you there. So I've given my opening remarks, and and look forward to the discussion. This is kind of by no means a sort of comprehensive, systematic audit of the decisions of the committee, but it is to try to give you a flavour of the kind of decisions the committee is making around admissibility. Admissibility is the ultimate hurdle for every case that's considered at an international level. And all, as we know, human rights treaties set down probably standard enough, we might call them terms and conditions, hurdles that you have to overcome to access remedies at an international level. And that's an important principle, because the state parties that are held to account at an international level, as a matter of principle, have a right to be able to respond and intervene and react appropriately to complaints around human rights, and in this instance, children's rights. So it's entirely in line with respect for state sovereignty that before you go to an international remedy, the state itself has had an opportunity to respond. So what you look at, what you see then with grounds of admissibility is where the margin lies, where is the threshold for giving the state that opportunity, putting an obligation or a duty on the individual who's seeking the remedy, and only when, if you like, there's been a reasonable efforts made on both parts, will permission be granted to cross over that hurdle of admissibility. And the CRC optional protocol on communications procedure is no different in that respect. So while these hurdles might be challenging and difficult, we have to understand that as a matter of international law, they are necessary. And they're necessary also to the credibility of the system that we're describing and that we're talking about today. So I'm going to talk to you about two remedies, and Jaap will pick up some other aspects of admissibility. I'm going to talk specifically about exhaustion of domestic remedies and about the concept of extraterritorial jurisdiction. Exhaustion of domestic remedies is exactly that criterion that I mentioned, that really requires that state parties have an opportunity to address an issue, a breach, a potential alleged breach of children's rights at a national level, and that the applicant or the complainant, the author of the communication, has taken on the responsibility of exhausting the remedies that might and are available at a national level. So what the protocol itself describes is in Article 7. It says, among other things, that the committee shall consider a communication inadmissible where, and we're concerned with the paragraph E here, all available domestic remedies have not been exhausted. This shall not be the rule where the application of the remedies is unreasonably prolonged or unlikely to bring effective relief. So inadmissible where all domestic remedies have not been exhausted. That's probably standard enough language, but it is significant that it's a reference to all available domestic remedies, indicating obviously remedies that are not available do not have to be exhausted, but there is an expectation that available remedies will be used. The caveat then being that will not apply where the application of the remedies is unreasonably prolonged. That's to prevent states obviously from dragging out an issue or a matter, an unreasonable delay or a prolongation of a process, and critically also then unlikely to bring effective relief. And that's in line with the general rule that you don't have to exhaust remedies that will not bring effective relief. So you don't have to go through the motions just because a remedy exists if, and as we will see, there's some parameters around this, it is unlikely to be successful. So I want to go through a couple of decisions of the committee which have addressed these issues, and specifically the question of exhaustion. And I want to start with the decision of DD against Spain. This was a case of effectively summary deportation of an unaccompanied child from Spain to Morocco. It was a slightly technical situation, that related to the definition of land borders and boundaries. But the key point was that the author, or the applicant in question, was returned from Spain to Morocco without a chance to object to his summary deportation, or even to claim protection as an unaccompanied child. There were no attempts made by the Spanish authorities to ask about his age. He didn't offer him any legal assistance or contact with an interpreter or any of the child support services or authorities. The communication, and we were obviously not concerned with the merits, but this was a communication that alleged Spain's a violation of rights under Article 3, best interests, and Article 20, special protection, as well as Article 37. I mean, the question was whether the individual had exhausted domestic remedies and was entitled then to have their application found admissible. The committee found that effectively, because there was no domestic remedy available, that there was no requirement to exhaust those remedies. In particular, I suppose the question was that because the committee found that because of the immediate nature, the immediate execution of the deportation, and the absence of any formal order that could actually be challenged, there was no need to require any remedies to be exhausted. So this was, if you like, a fairly straightforward situation in that sense, and that there was no remedy available, and on that basis, the complaint was found to be admissible. I should say that the question of determining whether or not a remedy is available can be a complex one, and it is notoriously difficult, I think it's fair to say, in immigration cases, because often of the heavily administrative nature of those processes. The remedy, for example, may not be in the context of immigration. It may in fact be a procedure that's in place to allow any administrative decision to be challenged. So it's not always a very straightforward process to determine whether in fact there is a remedy available at all. The next decision then deals with the case against Denmark, EP and FP. This was about an Albanian family and nationals, parents and their children, who argued that their rights would be violated by their deportation from Denmark to Albania. They were concerned in particular that the children's rights would be breached on the basis that the deportation would, if they were returned to Albania, subject them to a risk of torture by a virtue of an ongoing feud, and that was likely to impact on the children's rights and welfare. I mean, again, question became, you know, what effect would any challenge to that decision raise? And in particular, I suppose there had been an ongoing series of appeals, the result of which had not been conclusively determined when they made their application or their request to the committee to consider the matter. And equally, their request for judicial review was outstanding. And so the question was, with these outstanding or open-ended processes, were those required to be closed out before the committee would consider its decision? And the committee effectively found that because these processes, the appeal in particular, would not have suspended the execution of the deportation order, the remedies couldn't be considered effective. So even though they were involved in challenging the process, there was no evidence that that was going to have any substantive impact on the decision to deport them. And so the committee was clear that the remedy would not have impacted their deportation. And as a result, they were not required to close out those processes or those decisions to cross over that hurdle around exhaustion of domestic remedies. The next case then is a case of CE in Belgium. This is the refusal of a humanitarian visa to a child who had been entrusted to a Belgian-Moroccan couple in the context of kafala. You know, again, I suppose the question was related to the exhaustion of domestic remedies in particular. Belgium had argued that the communication should be considered inadmissible for failing to exhaust domestic remedies, since again the appeal process had been pending or was pending at the time of the communication, and it argued that it was considered an effective remedy by the state party. But again, I think similar to the case against Denmark, the committee found that the complaint was admissible because the appeals mechanism that was being used by the parties could not have overturned the decision to deport. So that question again, the body to which the parties were appealing did not have decision-making power. And so again, they had already used that appeals mechanism twice, and because they had done so without effect, if you like, the committee said that that was not something they were required to see through. So those were, I suppose, similar types of cases. There's a slightly different issue, and this was not the substantive issue involved in this case, which I'll come back to, which is really more interestingly one about extraterritorial jurisdiction. But the Yaksic case against Argentina, known as the climate justice case, taken and decided recently by the committee, taken by a number of children against a series of 5 states parties. Here, the question was, obviously there was a question as to whether children were required to exhaust domestic remedies. There was I think a fairly generous view in relation to exhaustion. Sorry, there was the question on extraterritorial application was where this decision was very interesting, which I'll come back to in a second. But in fact, here the argument was made that if they were to engage in litigation, engage in exhaustion of remedies at a national level, that it would prolong proceedings. And that was something that the committee rejected. So it's an interesting kind of net point on that question, which raises a lot of issues about exactly what remedies we have in the way of child applicants. But it's a case I'll come back to in a few minutes' time. And then the other one relates to voting rights of children in DC and Germany. Again, here where we have an interesting view by the committee, finding non-exhaustion on the basis of a failure to go to effectively a constitutional court. And I think this was a case of a child, 16 at the time, wanted to vote in the local elections for mayor. Application obviously was ultimately rejected because he wasn't 18, and had taken some measures to try to establish or to repeal that decision. You know, there had been some of those, but claims were rejected by those authorities. And there was some discussion about timelines and so on. But ultimately, you know, again, the state party claimed that the fact the child didn't commit the complaint to the Constitutional Court had deprived that court of the opportunity to comment on the application of the convention with regard to the relevant electoral law. And I think effectively the Committee on the Rights of the Child agreed, declaring the application of the communication to be inadmissible for failure to exhaust domestic remedies. And you know, the question of I suppose requiring authors to exhaust domestic remedies, it said, should be to interpret to relate only to those judicial and/or administrative avenues that can offer a reasonable and objective prospect of redress. That's from an earlier from that decision. The question, I suppose, that arises was what evidence had there been presented to support the view that the remedy was not likely to be effective, was not likely to guarantee or to present a prospect of redress. And the committee's view was that mere doubts or assumptions about the success or effectiveness of remedies was not sufficient. And so didn't absolve, it says, the authors from the requirement to exhaust domestic remedies. So this came down to the question of what evidence was required in relation to showing the approving to the committee's satisfaction that the remedy that it was at play provided or didn't provide, in this instance, a reasonable and objective prospect of redress. So that, in some respects, goes to the very heart of what exhaustion means in children's cases, setting a bar, I think, at a high level for not just the remedies to be exhausted, but actually the evidence that you are to propose and put forward as to why those remedies are unlikely to be effective. In terms of suppose, some comments viewing exhaustion from a children's rights perspective, it seems to me, in viewing the committee's decisions so far, and these are still very early days, I think, that the concept itself appears reasonably to be said to have been sort of transplanted from adult human rights law with relatively little regard for the kind of challenges that children face when they're securing remedies at a national level. And I think it's often missed that there is, in fact, no right under the Convention to access justice. Unlike other human rights treaties, there is no right to access effective remedies in the Convention. And it's an interesting irony, I suppose, that the committee, in imposing its demands on authors of complaints and those who have to access its procedures, are deprived of a fundamental right that might actually prove to offer exactly that which they seek at an international level. There's also in the Convention no right to take legal proceedings, and really very few provisions and to some extent very little guidance as yet from the committee on the structural barriers and how children either are to be supported to overcome those barriers, equally how the states are required to make procedures accessible to children. And I'd compare that compare that with the European guidelines on child-friendly justice, which very explicitly set out and recognise the child's right to access justice and have very clear guidance for states parties on how those barriers are to be overcome. And really firmly placing the duty on the state and state authorities to make the justice process accessible to children. By contrast, I think, and again, not to overstate it, but it does appear that the requirement around exhaustion in particular sets the bar really very high for children. And it doesn't appear to take sufficient regard, or have sufficient regard, to the very particular circumstances that children face and the structural barriers that they have to overcome. I should say, and I think it's evident so far, with some exceptions, that the cases that we're dealing with before the committee are largely those in which other adults are also involved. And there is a question to some extent, and it comes up in the Denmark case, I think, of the extent to which the committee is actually considering the substantive and procedural issues from the child's particular or individual perspective. or whether it's taking a more global view, expecting children to have a well-informed or professional legal representation or advocacy alongside them. So I think there's probably a technical sort of question about that as well. The other point that I wanted to address, how am I doing for time, Ton?
Ursula, I think you can take another 10 minutes.
Okay, perfect.
But take your time.
Yeah, perfect. Okay. So the other really, and again, I accept these are technical questions, and they may or may not be easily understood by a non-legal audience. But in terms of the extraterritorial jurisdiction, I think it's again, it's a question that arises with respect to the limits of responsibility on states parties to the convention with respect to their duty to fulfill, protect, and promote the rights of children. And there are two significant cases that address this point in particular. The issue in the main comes down to one of whether the state impugned in the case has effective control sufficient that it is in a position to offer a remedy or to respond to the alleged breaches of rights. So to some extent, there is a practical element to this, but there's also an element of principle. What is it that states should be expected to do? And really where this comes, and that's why the concept of effective control is in brackets, that this is the concept we're talking about, that connection between the point of principle and what effectively states have control over and are able to deliver by way of children's rights breaches or protection. So going back to the environmental and the climate justice case, this was a key issue in this case, as I'm sure many of you are aware. Let's put that here again. And there was there is a lot of jurisprudence, a lot of academic literature on the question of extraterritorial jurisdiction and a different views. There's a really excellent note on this in the Leiden Children's Rights Observatory database, where there is an analysis, I suppose, of the question of where the Committee on the Rights of the Child's view or approach to extraterritorial jurisdiction sits vis-a-vis that of other bodies. And I think in particular noting that the approach specifically of the European Court of Human Rights, the approach of the European Court is on the very conservative side, although interestingly it probably was one of the first bodies to reach a position on extraterritorial jurisdiction many years ago. So just to recap, I suppose this was a communication submitted by 16 children, claiming that 5 respondent states had breached their obligations under the convention by causing and perpetuating the climate crisis, resulting in ongoing violations of their convention rights. And this is really, interestingly, about sort of a trend towards holding states and corporations, indeed, to account for failure around climate action, inadequate response to climate action, with the result that constitutional human rights and in this case convention rights are being breached. And this is part of a campaign involving children and other parties around holding and I suppose identifying levels of accountability around the climate agenda. And I suppose the question, as I said, in relation became raised questions of admissibility, fundamental questions of admissibility that I'm also ones that I'm sort of not going to address, but in particular, I suppose the question of where this case I suppose was most interesting was around this question of extraterritorial jurisdiction, right? So, and in particular, I suppose it's important that the committee came down in favour of the test that the Inter-American Court of Human Rights had settled on, clarifying as a point of principle that persons whose rights have been violated as a result of transboundary damage are under the jurisdiction of the state of origin if there's a causal link between the act that originated in its territory and the infringement of the human rights of the person outside that territory. And the committee went on to apply that test to climate change, looking at a number of different elements that all related to the question of causation. So first of all, the state on whose territory the greenhouse gas emissions originated must exercise effective control over the sources of those emissions. Second, there has to be a causal link between the acts of the state and the negative impact on the rights of children located outside its territory. And third, that the alleged harm needs to have been reasonably foreseeable to the state at the time. And in short, the committee found in accepting that test and applying it to the case that the states in question had effective control over the sources of the emissions. And went on to find that it was foreseeability also was established based on the argument that the states in question had known about the harmful effects of climate change and had effective control in terms of responding. So that was a significant win, I think, in that case. Would have been seen to be one of the key issues, along with exhaustion of domestic remedies, on which the case would ultimately rest, and so it was proven to be. But I think, interestingly, that along with other cases, the causal effect was proven to the point that the states were being held to account in that context. I think a slightly in some respects more interesting case wasn't the French one that's listed there, LH, which is, if I understand it, if I'm correct, is also before the European Court of Human Rights. This is a case involving a number of parties, children born in France and taken by parents to Syria, where they remained at the time of the request in absolutely appalling circumstances of the Syrian camps. And the really interesting question here is to go back to the point about effective control. Obviously, France, as you'd expect, resisted that it had any responsibility for the rights of these children. But the committee, in its approach, took a very broad view, I think, of jurisdiction, talking about acts that are performed or that produce effects. So some elaboration, I think, of that concept of effective control. And really, I think, seemed to start from the point that responsibility for nationals outside the jurisdiction, outside the country, did fall within their jurisdiction, where there were other compelling factors. And in this instance, the compelling factors were the circumstances of the victims. The descriptions were of extreme vulnerability, deplorable conditions that posed an imminent risk to the rights of the children of a most serious kind. And then secondly, the committee finding that relevant was the state's capability and power to protect the rights of the children. So a really interesting assessment that actually, far from not having effective control, France, the respondent party in that case, did have both the capability and the power to protect the rights of those children. So it's an interesting, I think, point about states being placed under responsibility with respect to those within its jurisdiction, with a very, I think, potentially far-reaching effect of expanded jurisdiction. The final comments I'd make really in relation to admissibility, following on from my earlier remarks, is that it is to some extent, as those cases make clear, I think it certainly can be a highly technical process. And I think if we consider that the individual communications procedure, the communications procedure comes at the end of a very long road and process, including the exhaustion of domestic remedies where those are considered to be effective, can result in a very elongated and onerous journey for a child alleged victim of children's rights breaches. And it also seems in reviewing those number of cases that the ability or the capacity to breach or to reach over the hurdle of admissibility can be dependent on quite a range of factors, and the complexity of the cases will, I think, increasingly show that that is the case. And I think here we will see both the breadth of the convention itself and the number of states parties that can be impugned by the procedure to be really relevant in terms of, and I suppose that question of how the committee is on an ongoing basis to stay on top of that complexity, I think remains to be seen. I think we see still, as I said at the beginning, very little accommodation of children as litigators. You know, in a couple of the cases I've mentioned, you could see the origins of the children themselves in those cases, their capacity to shape the requests being made or the application being made. But in most instances, that's not going to be the case. And I think when we hear from Jaap, we'll get some sense as well of where that balance lies between the child and their supporting adults and whose complaint is being progressed. And I think ultimately, you know, notwithstanding the lamenting of the absence of remedies at a national level, it's very clear that that borderline between effective remedies for children at a national level, no remedies, is going to become a really critical one, where we'll see as the decisions develop the extent to which the committee is willing to accept a level of discretion, I suppose, as to what remedies are considered appropriate or effective for children to exhaust at a national level, and what simply is a hurdle or a barrier too far. So they're my sort of remarks for this afternoon, this morning. I'm really interested to hear what Jaap has to say, which I'm sure will add greatly to the complexity of and the understanding of these issues, and I look forward to the discussions in the time after that. Thanks very much.
Thank you very much, Ursula, for this journey towards several decisions of the committee in terms of admissibility to distinguish issues around technicalities of the protocol that clearly imply challenges and possibilities for innovation for the committee with respect to how we understand the admissibility requirements. Now I'm going to give the floor. I'd like to introduce Professor Jaap. I'm sorry about my pronunciation. Jaap is Professor Emeritus of Law in the Amsterdam University since 2004. Previously, he was a juvenile law professor from Leiden University between 1999 and 2004. And he was also Dean of the School of Law, Universiteit, between 1988 and 1992. He has extensive experience. He has been a visiting professor in Georgetown, Michigan, Oxford, and other universities. And importantly, I think he was a member of the Committee on the Rights of the Child between 1999 and 2007, and chair of subcommittee between 2001 and 2007. Finally, Jaap is a member of the academic committee of the Observatory of the Rights of the Child of the Leiden University that supports these seminars. So it is a pleasure to give the floor to Jaap. Go ahead, Professor.
The victim, the child, and any other kind of requirement. There is an interesting submission form. You should read it, and you would be surprised that you don't recognize anything that is relevant for submission to the Committee on the Rights of the Child. Like, I am the complainant, and there is no question on, do you have the consent of the person you are representing here? And please do attach the document that proves that you have the consent of the child. Anyway, there is a confusion on the role of parents. It's interesting. In the case against Spain, it was about the removal of a child from Switzerland to Spain. The father wanted to change that, and he went through all the necessary domestic remedies. And then when he came to the committee, Spain's argument was the father cannot represent the child because he has no custody. The committee made a very puzzling kind of remark on this position of Spain. A father without a custody can represent a child unless the communication is not in the interest of the child. Again, whether a person has the custody over a child or not is not relevant for his capacity to submit a communication on behalf of a child. You can do that as an NGO, you can do that as a neighbor of the child, you can do that as the grandfather of the child, it doesn't matter. So to make the custody an issue in this particular situation in the committee, observing that the father without custody can represent a child, whether that is at all or should it be a problem, unless, and now the particular interesting part, the communication is not in the interest of the child. So here, the father is subject to a criterion that I haven't seen in the rules nor in the protocol itself, that if you have submitted an admissible communication, that then that particular communication apparently can nevertheless be declared inadmissible if the communication is not in the interest of the child. So that is the first thing on the confusion around who can, on behalf of a child, submit a communication and what kind of specific information has to be provided to the committee. To me, it's not clear, and it should be made much more clear than it is right now. Next slide, please. The other issue is important, and that is that if somebody submits a communication on behalf of a child, that child should have given her or his consent. Again, back to the form for the submission of communication. Nothing in that document talks about the child as and her or his consent to that particular communication on behalf of her or him. Unless the lack of consent can be justified. An example of a justifiable lack of consent is the father had not seen the child or had any contact with the children, and he doesn't know where they live. That is the case I mentioned above of the removal of a child from Switzerland to Spain. And there was another interesting case in which the father claims that he has the right to act before the committee and therefore doesn't need the consent of the children. The committee didn't respond to that particular position of the father, but we may assume that that claim was inadmissible. So the working method, I have to come back to, the consent is the lack of consent and the consent of the child. And there is the issue, and I don't know whether it's in the next slide, but I don't think so. But the next issue is whether that particular consent was the result of a improper pressure or inducement by the person acting on behalf of the child. In the working method of the committee that deals with the working group on the communications, it says that the working group should examine whether there is a reason to believe that the child is subject to improper pressure or inducement by the person acting on her or his behalf. My suggestion to anybody who submits it on behalf of a child is not only to get a consent, but also to make clear in that submission that there has been no improper pressure or inducement on the child to make the child consent to the submission. But it is an important aspect that has not been sufficiently considered and discussed, whether the consent that has been given for the submission was really a well-informed consent and a voluntary provided consent to the person who wanted to submit that commission. That's communication. Okay, next slide, please. Here it is, another particular rule around the matter of consent. That is the rule that you will find in Rule 20, paragraph 4 of the Rules of Procedure of the Communication Protocol. If there is, on behalf of the child, a communication submitted without the evidence of consent, the committee may decide that it is not in the best interest of the child to examine the communication. Question I have is, does that mean, or does that suggest that the committee may examine the communication without the consent of the child, if that is in the best interest of the child? It's a very confusing rule and providing a kind of a tool, the best interest of the child, to the committee to decide whether to examine the communication or not. I think it's very questionable. If a communication is submitted on behalf of a child without her or his consent, that particular communication is inadmissible. So there is, in my view, no evidence. And that if there is no evidence of a consent, there is no reason for the rule of 20, paragraph 4. So that is another issue. Although, again, in practical terms, lessons learned here, if you communicate, if you submit a communication on behalf of a child and you don't have enough evidence, or you cannot provide sufficient evidence, you may call on the committee to nevertheless examine that communication, because that is in the best interest of the child. And you can do that with a reference to Rule 20, paragraph 4. Lack of consent is justified. So the complainant, the author of the communication, made clear why there was no consent from the children. Like the father, who didn't have any contact with the children, couldn't get any contact with the children, and therefore could not get the consent of the children. The communication can be submitted when the committee deems it to be in the best interest of the child. Rule 13, paragraph 3 of the Rules of Procedure. Again, the best interest of the child as a tool for the committee to do something that I don't find any justification for. The parent submits a communication on behalf of her or his child with explanation why the consent cannot be provided. And if the committee accepts that explanation and justification of the lack of consent, then, in my view, the communication is admissible. To allow the committee to deems it to be in the best interest of the child to examine the communication, I think, is, again, not based on the optional protocol. So what I like to draw your attention to is the curious use of the best interest of the child by the committee in whether to examine or not to examine a communication, even a communication that is, in my view, clearly under the rules of the Oslo Protocol, admissible. So that on the consent and on the matter of who is allowed to, who has the right to submit a communication on behalf of Jaap. Let's move to the other slide. The communication has already been examined by another procedure of international investigation or settlement, and then that particular communication is not admissible. There is some interesting case law by the committee that needs to be taken into account when you move to the committee with a case that already has been considered by, for instance, by the European Court on Human Rights. In the case of Finland, the European Court found that particular case inadmissible without specifying the basis for this finding. That is interesting because the committee did, in that particular case, that the European Court did not provide reasons for its finding that the case was inadmissible. And, well, it was enough for the committee to conclude that the case submitted to the committee was not the same matter as the one that was dealt with by the European Court on Human Rights. It's interesting if you ever go to a committee with a case that was examined by the European Court on Human Rights and found inadmissible, look at the reasoning, the arguments of the court for this particular finding. If that argument is either very weak or not existing at all, you may raise that because that is case law of the committee that would allow the committee, despite the fact that the European Court has considered it, to consider that case that is submitted to the committee not the same as the case before the European Court. The other case that was interesting, and I think it happens in other cases, but this one is that the case was dealt with by the Human Rights Committee, but not the claim that it would be in the best interest of the child to remain in Denmark. This is again also a case of a expulsion of children to Albania, and the other case also, there was a couple of cases against Denmark that were dealing with the expulsion or the decision to expel the children and the parent to Albania. But the Human Rights Committee in this case did not consider the claim that was raised in the course of the in the communication to the committee that it would be in the best interest of the child to remain, or the children to remain in Denmark. So it meant that the communication, although dealt with by the Human Rights Committee, was considered to be admissible. And there was a similar case also in the expulsion from Denmark to Albania, where the committee concluded, or was of the view, that there was no consideration given to the claims under Article 3, again, the best interest of the child, like in the previous case, but also not the right of education, the right of education of children, that apparently was an issue when the children were going to be moved to Albania. So it is interesting when you look at that particular ground for declaring a communication inadmissible, that if you have cases that were considered by other bodies, look carefully first on the reasoning when it is found inadmissible, but also to clearly look at whether the claims that you have were, let's say, sufficiently dealt with by either the Human Rights Committee or CEDAW or any other committee for that matter. The last slide. Incompatible with the provisions of the convention. Which there are a number of cases in which an adult claims that her or his rights have been violated. You will find it in cases on contact between parents and children, other family members that want to have contact with the children and fail to get that approved at the national level and went to the committee. And the committee was very clear in that matter and in similar matters as this one, the one against Spain, and also in case that I already mentioned before. The view of the committee is that the Convention on the Rights of the Child protects the rights of children and not the rights of adults. That kind of a general remark is, in my view, missing a point. And the question is whether that particular statement of the committee is correct in light of Article 18 and 27. 18, states parties shall render appropriate assistance to parents in the performance of their child rearing responsibilities. And 27 on the right to an adequate standard of living, that states parties shall take appropriate measures to assist parents and others responsible for the child to implement the rights mentioned in paragraph 1 of that article. That's the right on the standard of living. So that brings us to a case, or to the possibility of a case that has never been raised yet. But can a parent go through the national remedies claiming that she or he is not getting the appropriate assistance in the performance of their child rearing responsibilities, that particular claim has been rejected, and then you go to the committee, and whether the committee can again tell the parents, well, listen, this is the Convention on the Rights of the Child. So are you the parents? Well, unlucky, you are not, your rights are not protected in the convention. So that's all about what I have to say today. There is much more to tell about admissibility, but my final conclusion is whoever wants to go to the committee with a communication, very clearly is the advice to carefully consider all aspects of the admissibility. And as Ursula said, it is not easy, it's complicated. The committee is sometimes not as clear as I like it to be. And for people who submit a communication, look particular at cases comparable with yours and which were declared inadmissible and why they were declared inadmissible. That is providing you with some lessons that you can benefit from. That's all.
Thank you so very much, Jaap, for this very interesting lecture. Thank you, Ursula, as well. Thank you also for taking us through the case law as it stands. And as Ursula was saying, it's early. We still have to find out how things develop from here. Yet we also see more and more coming out of this particular communication procedure that help us to understand the added value of the mechanism with all in all its elements, and including the procedural elements that start with the questions around admissibility. Thank you also, Jaap, for making that final point, that if you really litigate on behalf of children, that you also take good care of the admissibility, good notice of the admissibility criteria, because the committee is seriously looking into these, of course, which will also contribute to the credibility of the whole mechanism. One question to start with. Before I ask my question, maybe first I would like to draw your attention to Jaap Doek's report on admissibility and all the admissibility decisions that have been delivered so far by the committee, and it can be found on the Leiden Children's Rights Observatory. We will give you the link in the chat in the course of this webinar series, which has also been translated into Spanish. So for those who would like to seek access to the documentation that is underlying the Jaap Doek's contribution of tonight, please feel free to visit there. But coming back to the lectures, thank you again. And I would like to start by asking the following question: is that the committee has, or committee members have actually again and again highlighted the importance of investing in domestic remedies for children. And maybe one of the key functions of this international mechanism is also to stimulate the effective domestic remedies, and also to challenge also barriers that children face when they seek effective remedies at the domestic level. Maybe Ursula first, do you recognize that approach also in the way the committee deals with the issue of exhaustion of domestic remedies? Is this primacy of the domestic arena as the place where children should go first, but also maybe are best off in terms of finding their remedies?
Well, that's a nice, easy question to start. Thanks, Ton. Yeah, so I think what you're suggesting is that there's a principle at play here, and that the committee is working to a principle that exhaustion, or the requirement to exhaust domestic remedies, really is about putting the responsibility back on the state party, if not in this case, in other cases, to properly provide a remedy for children who allege their rights are breached. It's difficult, I think, to say just yet. I mean, and I guess, I mean, we've in the very early days had a lot of cases on immigration matters, which are notoriously difficult to litigate anyway, and where the remedies tend to be non-specific at national level, and tend to be perhaps scattergun at an international level. Applicants who are active tend to use available remedies across the board. But I suppose there is some understanding in the committee's decisions that not every mechanism will be effective, but I don't see as yet any great discussion of or elaboration on what remedy may be more effective from a children's rights perspective than in the general technical sense. So I think it probably will I'm hoping that more principled reasoning will come through the decisions as the process evolves. Some of this is quite technical, as I said, and quite, I would say, it is formalistic, and it's, I mean, in particular, I suppose, you know, in terms of the Syrian case, that the reasoning is not entirely clear. It seems focused on the end rather than the process. So I think that's a challenge. And I think the committee is probably struggling a little bit with the breadth of these issues that don't exist in isolation in the Committee on the Rights of the Child. They exist throughout international human rights law. And so the committee has to be careful not to, you know, reinvent the wheel, as it were, but it does need, and this is, I think, where it falls down, it does need to be the advocate for effective remedies for children. And I think that is an important, and I think that to Jaap's really important observations about those who are looking to use the mechanism, I think it's really important for those who have a strategic mindset and approach to think about how arguments can be articulated in a sense that particularly that the committee is asked not to simply find a remedy to be ineffective, but actually it's ineffective for children. I think if we were to start pushing the committee in that direction, we might see a little bit more coming from the decisions then that would help us use those decisions then to put pressure on the national level.
Thank you so much, Ursula, for that. Jaap, listening to you, maybe you may wonder how we could use the experience that we are now gaining also at the domestic level. There's one question in the Q&A by Yatsiel Martinez, and she, referring to judges in Mexico always asking for the custody when there is a representative in court. And you were referring to the fact that maybe consent should not be, of representing should not be made dependent on having custody or not. The question there is, can we use this also at the national level to make that case? What would be your advice to that particular participant?
Well, generally speaking, I think that, and following Ursula's observations, at the national level, I think access to justice should be made much easier for children than it currently is. And to require as an absolute condition that the child has to be represented by a person who has the custody over the child is not only limiting the access to justice, but also apparently doesn't recognize possible conflict of interest between the custodian and the child. And in that case, if the custodian doesn't want to access court in the interest of the child for a certain violation of the rights of the child, for whatever reason, that is, in my view, under the convention and under human rights in general, an unacceptable limitation. Because why would a child be absolutely dependent on the custodian for getting access to justice? So, as you know, in the Netherlands, we have what they call the curator or the special curator that can be appointed by the court at the request of the child, informal request. There is no formal procedure necessary to represent the child in the case that the child wants to raise before the court. So that is important. When it comes to the optional protocol, I'm not sure, but it's some of those issues for research. My assumption, or let's say my hope, is that if a country has ratified the optional protocol, it is also facing the need to make the national remedies as good and as accessible as possible in order to avoid that you have to meet with the committee in Geneva that tells you that you are not okay with your access to justice at the national level for children. So it's interesting to see whether in the 48 countries that have currently ratified the Oslo Protocol, whether that had an impact on the practice of access to justice at the national level.
That is a very good question. On the long run, do we see that impact? Do we see that happening? That there is indeed domestic developments that are pushed for also by this mechanism, or by the implications of the outcomes of the cases.
I would just add
Please,
to that point, Tom, that I think it's a really there's a really interesting question there about what form of remedies are appropriate for to address violations or alleged breaches of children's rights under the Convention. Given the breadth of the Convention and the range of areas where children are likely to be impacted, the range of areas where they're likely to have complaints and concerns about breaches of their rights is going to be extensive and is extensive. So unless the committee is to start, I think, really articulating and putting shape on the guidance that it offers to support states to develop these remedies more effectively, I think states would rightly think, well, we have remedies in 5 key areas, but this is what we could do. And I suppose one of the really logical links here is with national human rights institutions, and whether, to what extent, the committee can really start to look at those, particularly those institutions which have complaints functions. Ireland is one of those countries that has a complaints function in its ombudsman for children, having also ratified the optional protocol. So it'll be interesting to see in time whether the ombudsman's complaint mechanism is seen to be an effective remedy when it has caveats and gaps in it. So I don't think we should underestimate how complex this is for states parties either. And I think some level of mapping out at a national level what those remedies look like might be useful exercise for those who want to then present a coherent case to the committee around exhaustion. And then on the flip side, then obviously for developing effective remedies for children at a national level.
Yeah, very interesting observation. Also the link to the national human rights institutions, the children's commissioners, children's ombudspersons, and particularly if they have a complaint mechanism. Thank you for these observations. There is one other question from one of the participants, and that is about the accessibility in terms of information about the communications procedures to children, and there's the suggestion maybe there should be much more accessible information about this whole mechanism. And a practical question, in fact, also is would that be helpful to have more, to have the optional protocol being translated into child-friendly language, to promote forms and rules of procedure in much more accessible terms? What are your views on that? Either one of you. Jaap.
I'm the father of 4 daughters, so goes first.
All right, Ursula.
Yeah, there's no question. We are not very far along in our development of mechanisms and approaches that make justice accessible for children generally, and I think there's absolutely a case to be made for the committee to advance the accessibility of the optional protocol. I mean, as Jaap had said already, and as those of us who were observing it from the beginning, we haven't done particularly well so far in adapting the mechanism itself. So I think there's still only so much we can do to make it accessible through our communication. Nonetheless, I think it is critically important that we support children in all ways possible to understand their rights and to seek remedies to for alleged breaches of those rights, including on to the optional protocol. It's difficult, given the legal technical nature of some of this, in not so much in communicating. I think we could do that. It's the question of the making that communication effective in terms of the access. But I think there are lots of initiatives underway to address these issues and also to make laws more accessible to children generally. I think there's a whole body of work there at a national level too.
All right. Thank you so much, Ursula. Thank you so much, Jaap. I will now hand over back to Nico to close this session.
Sí, muchas gracias, Jaap.
Yes, thank you very much, Jaap, Ursula, Ton. Unfortunately, we are running out of time for this session. I'd like to thank you and make an important remark, which is there are structural issues for the access of justice of children that have an impact on the possibility and the effectiveness of the protocol. And consequently, this is a very important and innovative tool that has to be ratified for even more states. And by the way, the structural conditions of the lack of access to adequate and justice that is friendly to children can not only have an impact on the protection of their rights internally, but also be transplanted to the access of justice to an international forum like the committee. So that's the challenge for me. It is a cycle of use of the different fora to pressure for a better justice and use of resources or remedies to have access to justice. So a personal reflection is that it is important that strategic litigation that is taking place before the Committee on the Rights of the Child to include this. That is, not only pay attention to substantive actions, rights that can be breached, but also we will find later on cases that represent this, the absence of resources or remedies. We have 2 more comments. Unfortunately, we have to close this session. I'd like to thank you on behalf of the Center for Constitutional Studies of the Supreme Court of Justice of Mexico and the School of Law of Leiden University, Professor Jaap, Professor Ursula Kilkelly, and we invite you to our next session on January 18. This is the third session of this cycle of conferences. We will let you know via Twitter and our social media, and we invite you to visit the website of the Observatory of the Rights of the Child. We can share the website in the chat. You can use this as a discussion and work tool. Thank you very much. Good morning, afternoon, and evening.